last knowledge dot point. It's called The Ability of Parliament and the Courts to Respond to the Need for Law Reform. And I'm going to take you through here. So our goal is to evaluate the ability of both Parliament and the courts to respond to law reform. Your accessing prior knowledge or your Activate task is to write 2 sentences, a 2-sentence response to the question, responding to the need for law reform, who does it better? Parliament or the courts. And you need to use at least one word from each column. Remember, we are thinking really explicitly about the language features we're using, so do that now. In terms of the new information, let's start by talking about Parliament's ability to respond to the need for law reform. And yes, this overlaps significantly with other dot points that we've looked at. We know Parliament is supreme. Their primary role is to develop legislation and apply it to future fact situations to protect the community and respond continually to the need for law reform and enhance the legal system, cohesion of society and uphold human rights. Bit on, right? But that's kind of their primary role. And so members of Parliament strive to make laws that reflect the will of the people, but they're limited in that they are susceptible to political pressures. We looked at those in the first part of the outcome, and the fear of voter backlash. So we know that these things can make them reluctant to legislate with respect to controversial matters. That's just an intro. If we're breaking this down and we're looking at doing it so that you can discuss, in terms of the constitutional power of Parliament, obviously lawmaking is Parliament's primary role and it's required to do that, okay? For example, the Commonwealth passed the Marriage Amendment Definition and Religious Freedoms Act in 2017 in response to the national plebiscite on same-sex marriage, okay? The reason why constitutional is in here is because we are talking about the division of powers, okay? We know that Parliament's role is to make laws within its lawmaking power, okay? Within the powers that are outlined in the Constitution. It is supposed to be doing that, and it's supposed to be doing that in line with the principles of responsible government and of representative government, okay? Limitations we know about the legislative process is it is very time consuming. There's a number of reading stages. It's often sent to parliamentary committees. Parliament is not always sitting, which restricts this ability further. For example, Parliament may only sit 20 weeks of the year, and this means that they may be really slow to respond to new issues in society, although Parliament can be recalled from a break if needed urgently to respond to a situation. But that's what we'd look at if we're talking about Parliament's lawmaking ability. That's their primary function, and so they're able to do that really swiftly and proactively, but also we know time-consuming, limited by the number of sitting days in the year, and that we're talking about the number of days that parliamentarians are in there debating legislation and doing the work of Parliament, okay? Second thing is the level of community support. So we know representative government outlined or guaranteed by Section 7 and 24 means that members are elected by the people to best represent their views. It means that Parliaments should pass laws that reflect the will of the people and in response to changing social attitudes, or they obviously risk being voted out. So they should be passing legislation that reflects the will of people in their electorates. Limitations is, of course, often there are conflicting views. It may hinder lawmaking. Parliament could be concerned with backlash. Remember, we've covered this quite extensively in the last outcome, so you can read that yourself, but that's what you would include in a discuss. Thirdly, the ability to assess the need of the community and measures that support is one key strength of Parliament, okay? So obviously Parliament's able to do things like convene parliamentary committees, royal commissions, and they can use law reform bodies like the VLRC to do extensive research and consultation with the community. Their access to these bodies mean that they are often going to be producing new laws that are closely aligned to community values. And Parliament is supreme and therefore can make laws whenever a need arises. Really proactive, right? It doesn't have to reactively wait for those laws like the courts. Of course, on the other side of this is the fact that research into law reform can be expensive and can take a long time. It can take, for the reasons of, what's involved in coordinating panels of expert staff, etc. You can read that yourself. Also, the Victorian and Commonwealth Parliament are limited in their lawmaking power by their jurisdictions, okay? Those things that are outlined in the Constitution, remember? And if they do anything beyond that, they're likely to get pulled up if someone takes a case to court. All right, in our the other slide, so not this version, there was also these other two things that were mentioned. I think if you commit these three to memory, you'll be okay. But if you want these additional ones in your swag bag, go for it. So the composition of the Houses of Parliament. Remember, we've talked about this too. It can be difficult for the government to implement law reform if they don't have a majority in both houses, both lower and upper. And also a minority government in the lower house can mean that there has to be significant negotiation with the crossbench and with minor parties. Financial constraints can also be an issue and is one we haven't spoken about that in that much detail, but of course Parliament may be limited by budget constraints and some law reform may be incredibly costly to implement. Parliament may also be reluctant to support change in the law, which would lead to a decrease in government revenue. And a really good example of this is the gambling industry. So while morally we may want to regulate this, we can't deny that the government actually does make a lot of money off gambling. Okay, I've assigned you a worksheet on Classroom and there is a part A of that worksheet. So I'd like you to work through that now. So you're just going to choose, I think, two. If we look at this, here, two aspects of Parliament's ability to respond. Aspect 1, tell me a strength or weakness. Tell me if it's a strength or weakness, and a second aspect, and is it a strength or a weakness? And then you need to say, how does this aspect improve or limit the ability of Parliament to respond to the need of law reform in 2 points of detail, 1 and 2. Okay. Alrighty, so the ability of courts to respond to law reform is the next part of this. And so it's a pretty big lesson. I might suggest even working through the resources on COGS across 2 lessons, but I will be giving you a practice sack for the next one. So courts are fundamentally more limited in their ability to respond to law reform because remember, their primary role is to adjudicate cases. And only if there's no law, if it's unclear, are they able to develop common law. Employing the flexibility provided through reversing, overruling and distinguishing, judges also can develop common law and can avoid precedent as well. Furthermore, the courts can, through the decisions in oratio decidendi, remember the reasons for the decision, and obiter dicta, anything else, other statements made in the judgment, they can put pressure on Parliament to make changes. However, courts are limited because they must wait for a case to come before them. We know this. So here are the things that you might want to talk about. So we've got jurisdiction and lawmaking authority. So when the need arises to change the law, courts can do this quite quickly compared to Parliament, and so they can interpret the law and develop precedent, and it allows them to do that gap-filling exercise when new issues arise. A limitation, remember, is they must wait for a case, and this can be slow because of the court hierarchy, because of that requirement for standing, because of the time and the finance that's, the financial considerations of bringing a case to court. So the development of an area of law can therefore take a long time, and they can't initiate a change proactively. The independence of the courts is another key strength. So they're appointed by the Crown on the advice of ministers, and they have we actually have gotten rid of life tenure on the High Court. I think High Court judges now retire at age 75. And so it ensures, although they're appointed, they are independent of the government, okay? They are not members of the government. They are not members of the Parliament at all. We have the separation of powers and their independence of their decisions, as that means that their focus is solely on the application of law. They're not concerned with pleasing voters or getting re-elected or anything like that. And so it allows them to develop the law without fear of things like voter backlash. Of course, on the other side of that coin is the fact that because they're not elected, they don't represent the views of the people, and therefore they, could be considered less appropriate as people who develop law, okay? And creates the risk of inappropriate laws being created or maintained. The ability to influence Parliament, we know, is significant. So decisions made and through obiter dictum, so other statements in a judgment, these things can all influence Parliament to make legislative change. Limits on this is the fact that courts apply the law ex post facto, meaning retrospectively to the case, okay? They're unable to preempt changes. They need to respond to a situation that's landed in front of them. The lawmaking process used by courts, with representatives finding and presenting persuasive precedents and a judge delivering written reasons, is kind of inefficient. In developing common law, there's no process in the courts whereby society's best interests can be debated. No ability to seek expert opinion or community attitudes, okay? It's very much left up to that judicial officer. Willingness to adopt an activist approach. Now we know this. Activist judges will consider a broad range of factors in their judgment. The High Court can develop and adapt law as they're not bound by other decisions, and they can actually take a really activist approach to developing common law, but it's not very common. The kind of activism we saw in the Mabo case in the early 90s is not common. Instead, judicial conservatism can limit the court's ability to influence lawmaking. Judges may be reluctant to change the law because they believe it's their role to narrowly interpret through just their adjudication of the case. Okay, they think that is their primary role, and they believe that it's best left to Parliament to do the development of the law. Here's in a nutshell strengths and weaknesses of courts as lawmakers. And I guess when we're thinking about this particular dot point, we are thinking specifically about the ability to respond to the need for law reform. So not getting yourself tied up with other dot points, but in terms of their ability to, respond to different needs that are identified, areas for law reform, here are our strengths and here are our corresponding weaknesses. So you need to be really familiar with that. And I've put in that little nutshell slide for you if you found the previous ones perhaps a bit overwhelming. Okay, I want you to complete part B of your worksheet. So you need to choose two aspects of the court's ability to respond. Tell me if it's a strength or a weakness. And then describe in 2 points of detail how that aspect improves or limits the ability of the courts to respond to the need for law reform. Once you've done that, you're on to our practice question. So we have this excerpt from a bit of reporting about marriage equality, the passage of marriage equality legislation in 2017 here. And then the question, explain why Parliament was effective at responding to the need for law reform in this instance. Explain is our task term. Why Parliament, we're not talking about the courts, was effective at responding to the need for law reform in this instance. Okay, I want you to decode this question, write it down and have a go. You know you've got 4.5 minutes to get that done. All right. When you come back, this is the marking guide. So you need to have stated why Parliament was effective. You need to have described how they've been effective. And you must have used the stimulus in your prompt. And you needed to use key terminology like legislative change, law reform, plebiscite. Here is a sample response for you. So I won't read through this. You can do it at your leisure. This is pretty extensive for a 3-marker, but you know that we love to make sure that we've got everything covered off. I think some of this stuff about representative government could probably be axed and get really into referring to the stimulus. So in this instance, Federal Parliament passed marriage equality legislation to ensure people of the same sex could marry. It's evidence of the Parliament's ability to respond, as there's been considerable push from the community for a number of years. Talk about the controversial nature, but then again, talk about the fact that Parliament was able to act decisively once they polled the nation's people. Here's a big kahuna from the 2015 exam. Very, again, pre this study design, but still very relevant. Discuss the extent to which courts are able to overcome the limitations of Parliament in making laws. This comes straight from this lesson. So I would love you to at least write up an answer plan for this. So you are looking at, if we go back to our in a nutshell thing, in a nutshell summary, how are the courts able to, in this zone, in their strengths, overcome the weaknesses of Parliament as lawmakers? And so you're looking to do kind of a comparison here, but here are the key takeaways from the VCAR examination report. So students had to demonstrate their understanding of the limitations of Parliament in making laws and the extent to which courts could overcome these. Highest scoring responses provided a comprehensive and detailed discussion answering extent to which, and using paragraphs, of course, always. We're treating our 10 markers like mini essays. Students could write their first detailed point using a plan like this. limitation of Parliament, not often sitting, limited sitting days. Courts can overcome that. They can somewhat overcome this because they're not restricted by sitting days. Any limitation on courts, when overcoming it, well, we know they still have to wait for a case. You could then plan the following point. So another limitation of Parliament, they're elected. They're often reluctant to make controversial laws. Courts can overcome that because they're not elected, not subject to political pressure. But they also still have to wait for a case, critically, always coming back to that. So I would like you to try an answer plan for this, and you've got a couple of sentence starters here, so do look at that, and you're absolutely welcome to bring some responses with you when we meet again next term. So the language in this study design has changed slightly. Make sure your plans have focus on the ability of Parliament and the courts to respond to the need for law reform. And that's what we are talking about. Alrighty, here's another practice exam question for you, but I think that's enough from me. Get cracking. In fact, what I'll say actually is that because this goes over 2 lessons, it's super dense, you can have a go at responding to this 10-mark question in your final lesson of the week.